Hi everyone, welcome back to the web series. Today we are going to be talking about patents. This is going to be a web series and it's just not one set of web seminar because patent is a vast subject and I think it requires a lot of time. Therefore, today I'm just going to be discussing about the definition of patents, what is a patent and what can constitute an invention. Those of you who don't know who I am, and let me just introduce myself. I'm Indu Verma. I'm an attorney licensed to practice in New York as well as in India. I'm also a registered patent agent in India. We do a lot of national as well as international patent applications through our office. If you need any further information about the work that we do, free feel to log on to www.induvarma.co. That's induvarma.co. So let's begin today's session. What constitutes a patent? Patent is a certification of exclusive right granted to an inventor for the invention that the inventor has invented. When I say an invention, you would have to know what an invention is under the Act. That is the Indian Patent Act. Invention would have to be something which is new. It has to be a process or a product which is new, which is non-obvious. It has to involve an inventive step, and it should be capable of industrial application. Let's take one by one. What is new? New is something which is not existent in the public domain. It should not be something which is already published. If it's published, then it's in the public domain. People know about it. Therefore, there's nothing new about it. Therefore, whatever you call as an invention that you want to patent, you would have to make sure that this is new. It is not something which is already published. Second, you'd have to check if it is obvious or not. What would be obvious? Something which is already existent in the market, as in if there is an invention already and your product or process is very similar to that what is already existent, and it is possible for the person skilled in the art to anticipate a product or a process like yours to be made or invented from what is already existing, then it is it's not something which fits into the patentability criteria, because it's anticipated by a person skilled in the art, that is skilled in that particular area, that such a product could be made. Therefore, there's nothing new or non-obvious about it. It is obvious that such a product can be made, and therefore it does not fit into the patentability criteria. So therefore, you have to make sure that your product, your invention is new and it is not obvious. Thirdly, it has to be something which involves an inventive step. What constitutes an inventive step? An inventive step is where there is a technical advancement from what is already existing in the public domain or in any of the patents. So if there is some kind of technical advancement, and if the technical advancement has economic significance, then your invention would have inventive step in it. The fourth thing that you have to consider is whether your product or process is capable of industrial application, which means if it is possible that your product can be made or can be used, then it fits into the criteria of industrial application. Therefore, for a patent to be given to an invention, your application should fit into the criteria of an invention, which means your patent application or your invention should be something which is new, which is non-obvious, which has a technical step involved, and as in an inventive step involved, it is of economic significance, and that it is capable of being used by people, or it can be made in a manufacturing unit. Now, this is what this explains what a patent is. For you to file a patent, you also have to check if it falls under any of the exceptions provided under the Act. That is the Act provides certain exceptions on certain processes and products or items that cannot be patented. So that is under Section 3 and Section 4 of the Indian Patent Act, which I will not be getting into detail today because it needs a lot of time for explanation. So I would probably bring that as a different series to discuss about what cannot be patented under Section 3 and Section 4. So as of now, we have covered what is a patent and what would constitute an invention. Therefore, when you file an application, make sure you have a checklist and you do cover these particular areas. That is, you do have an invention which is new, which is non-obvious, which involves an inventive step, and it is capable of industrial application. And also, further, it does not fall under the exceptions of Section 3 and Section 4 of the Indian Patent Act. I hope I've made myself clear in this session. If you have any queries on what I've just said, feel free to email me at info@induvarma.co. Hope to see you in our next session. Do join us. Thank you very much for being a part of this web seminar.